So this is kind of a brief outline of what we're going to be covering, and the focus is very much on helping you all to understand the planning process a bit more, and particularly at what stage in the process you're able to contribute and how to make an effective representation. And then at the end of my presentation, I'm going to look just at a couple of examples to issues like building heights and development density, which I know is particularly interesting to you all, and kind of set out how you might begin to think about some of these issues in terms of framing an objection. But I'll briefly cover some background about policy and legislation and the stages of a planning application first. So this is just kind of briefly kind of to set out kind of our philosophy about why it's important to participate in planning. As Cohen already said, we think it's very important that residents and local people kind of use their rights to be involved in the process, because you have those rights and it's really the most important and easiest way of communicating them through to the people who are making the decisions. But it's also important that people understand kind of the limits of those rights, what counts as planning, what doesn't count as planning, and really kind of the limits of your influence. So hopefully we'll touch on that in a little bit as well. So obviously this evening we're focusing very much on how to have your say on a planning application and how to comment on it. But I've included this slide just to kind of point out that it really obviously isn't the only way to influence planning. Being organised is incredibly important, which you already are, which is fantastic. And I really believe that there is strength in numbers when it comes to influencing planning decisions. Raising awareness in the community, and especially with your ward councillors, is crucial. In my experience, having a councillor advocating for your position in terms of planning applications is really invaluable and carries an enormous amount of weight, certainly in my borough. And of course, you can also respond to consultations on policy documents and planning documents when they come through. Obviously, that's less frequent, but it is your chance to kind of shape the policies themselves that we're making decisions based on. But obviously, this evening we're focusing on planning applications and how to comment on those specifically. So I've included this slide just by way of background, really, just to touch a little bit on our main act, which is the Town and Country Planning Act. And that places all significant decisions about the use of land and the development of land by private interests in the hands of public decision makers and in the hands of government. And I always think it's useful to point out that this makes it actually quite unusual in terms of Western planning systems. So like the US or Australia, it's a lot more zone-based. Building codes applications are kind of more of a tick box exercise. Whereas in the UK, actually quite unusual, and I think quite special, that lots of each application that comes through is got a chance for the public to comment, and it's being assessed by an expert, and kind of decisions are made in a much more democratic way. So I think that's kind of a useful comparison to make. And our secondary legislation, our statutory instrument, and the DMPO, that's also just key. It sort of sets out how we handle applications and the legal requirements surrounding validation, consultation, etc. I've just included this list on the right-hand side there. I'm not going to go through them all, but just to kind of make the point that there's lots of different pieces of legislation that relate to planning to try and keep track of. And this one there in red, the Business and Planning Act, that's the most recent, and that was really the government's response to COVID, included things like provisions to have virtual committees, extension to life of planning permissions for people who couldn't implement them due to the pandemic and things like that. So that's just a bit of background on that. And this is the planning policy hierarchy. So policy is obviously the guiding principles by which we all have to make decisions on individual applications, and there's several layers. At the national level is the NPPF, and that's written by a national government. It's really just sort of broad brush principles, a direction of travel for how the government wants to see development go ahead in the country. And it includes the presumption in favour of sustainable development, which essentially sets out the government's expectation that development will go ahead unless there's good reasons for it not to. So it's very much, the presumption is in favour of development. In London, we also have a regional tier. We have the London Plan, which is brand new in March this year. Well, the current version is brand new, and that's the Mayor's vision for London and policies for London-wide. And then each borough also has a local plan and probably has supplementary planning documents as well. And that's really kind of the finest grain of policies that kind of relate to individual planning applications in each borough. I don't know too much about neighbourhood plans because I don't have any in my borough, but if perhaps if there are some in Southwark, we can pick that up and speak about that a little bit later on. And also I'll just say while I'm on this is that each plan has a requirement to kind of be in conformity with the one above it. So Southwark's local plan needs to conform with the London plan needs to conform with the NPPF, so hopefully everything should be kind of consistent in that respect. I'm sure you will know much more about Southwark's new local plan than I do, but I kind of understand that there's a new one going to be published very soon, later this year, and once that's adopted, it'll be usually in place for about 10 years, or look forward to 10 years, and it's good that it's sort of coming in step with the London plan, so that's exciting. I'm sure we might hear an update about that shortly. So I thought it would be helpful to briefly set out kind of the stages of a planning application, because I'm aware that perhaps the process can be quite opaque if you're not dealing with them every day, and also to try and highlight where exactly your comments and things will come in. So firstly is pre-application advice. It's often charged, it's not compulsory, and it is confidential to the developer. So the council can't release what they've said at pre-application stage to the public or to residents. But importantly, it's also not binding on the council. So it's entirely legitimate for the council to say one thing at pre-application advice and then make a different decision when they come to determine the application. The next stage will obviously just be submission and validation of the application. That's really just checking it's complete. Validation in this context just means that we have all of the documents there. We have to validate something if it's complete. We can't kind of refuse to validate an application if all of the requirements have been met. And I think that's something sometimes people get confused about. They wonder why we've even bothered to validate something if we're not happy with it, but it's a legal requirement. So the consultation period starts immediately after we've received an application, and this is your chance to make a comment. So there'll be site notices, press adverts to try and get the word out. Adjoining properties may be sent letters, and at the same time we'll also consult our other council colleagues, external bodies, statutory consultees, and depending on the size of the application, there might always also be a stage 1 referral to the GLA. So that consultation period, it's statutory set out for 21 days. And after that has finished, hopefully we've got everybody's comments in, and the officer will make an assessment. They'll consider compliance with the relevant policies, standards, consider all the consultees we've received from everybody, and then ultimately kind of sum up and make a judgment as to whether or not they think the proposal's acceptable. At this stage, there may also be revisions and reconsultation required. So it's quite common for us to get revisions to plans, like officers will request revisions. They're not always so important that we have to go back out to consultation, but sometimes they are. So that might explain why you get several consultation letters for a single planning application. So once the officers sort of made their decision, they'll make a recommendation, and sometimes it will be what we call delegated, which just means that, say, another officer like my manager will just review it and issue the decision. That tends to be for smaller scale applications or less controversial ones. More likely, I think, for some of the schemes we're talking about this evening would be that they would go forward to the planning committee, and residents groups may also have the chance to speak at its committee, and I'm sure each borough kind of has its own protocol and procedure for that, which should be online. So that's another opportunity for you to put forward your views. Once the council's made a resolution or decided whether or not they're going to approve something or refuse it, there might be a stage 2 referral to the GLA, which is essentially sending it back to the mayor for him to either agree with the council or disagree and take steps as appropriate. And if anyone has questions on that, we can perhaps talk about that afterwards. And then the final decision, but that's obviously not the end of the story. There are options for a judicial review by a third party if they're unhappy with the decision or they think it's erred in law. If it's refused, obviously the applicant can appeal it. And if anyone's still not happy with how things have been handled, then there is also the option to complain to the local government ombudsman. So what are your rights in all of this? So as I kind of highlighted previously, you have a right to be consulted. We're required by law to undertake a 21-day public consultation, and that happens at the beginning of the process. Councils do have some discretion over how they inform residents, so most will send letters or publish a site notice and press advert and place details on the website. Anyone can respond, and there is no obligation for the council to take into account comments made after the closing date, which is really key. So I put a little bit here about what to expect after you've commented, because I sometimes find that people's expectations about their involvement in the process after they've made a comment perhaps don't always match up with reality. So if you'd like an acknowledgement, you should ask for one. It might not be automatic. You should remember that your comments will be in the public domain. So anything you say about anyone else will be public. It is your responsibility to stay informed about potential committee dates. So if you're interested in a case and you want to speak at committee, I would advise that you maybe sign up for the alerts for that particular application so you can stay up to date with what's going on with it, and you might be able to speak. And I think you should also expect that your concerns will at least be summarised and responded to somewhere in the report, so you can, in the officer's report that is, so you can see what you've said reflected and see what the case officer has had to say about that. So I wanted to include a few of what I think are kind of my tips for making an effective representation. I probably read in excess of 10,000 of them in my career so far, so I really have seen it all. It's really important that they're on time. So if you need more time, that might be okay, but I would strongly suggest that you make that request to the case officer and get them to agree to it in writing. Your comments should focus on the elements of the planning system, on the issues that are actually relevant to planning when you're making a comment. So those are called material considerations, and I've got a slide on that following this. It's really useful to link your concerns to specific policies in the plan if you're able to, and you'll kind of feel confident doing that. And I'm also going to touch on that a little bit later on as well. But I don't think anyone should feel that it's essential if you don't feel confident kind of ranging through the plan and picking out the policies, or you don't feel confident framing it in those terms. But it is really useful if it helps the case officer to kind of see things from your perspective in the way that they're going to be assessing it when they come to do their report. I definitely can keep it concise, bullet points and headings. The case officer probably is going to be reading hundreds of objections, and they really want to just skim through and kind of pick out the key points. I always find it useful if people include photos from your property or your public areas to kind of illustrate your points. For example, maybe from the park, or just anything really to kind of illustrate your point and make it more kind of visually impactful for the case officer. It's useful to make suggestions for changes if you think there are any. Like obviously sometimes people just think the development is just flat out unacceptable, and that's fine too. But if you think there are some changes that could make it acceptable, it's always really useful to highlight those. And just be clear, I think, about what your kind of ideal outcome would be. Like, would it just be that the application's refused? Could it be that it's changed in any way? Or is it possible that there might be just a condition that could address your concerns? And I guess that would very much depend on the nature of them. In terms of engaging a professional consultant to object for you, people do it, but it's perhaps not as common as you might think. I personally don't think it should be necessary. I think it's much more important to just set out your concerns, such as they are, just in kind of plain English and just in layperson's terms. It certainly doesn't carry any more weight with officers if it's done by a consultant. But if you want to, by all means, there's plenty of consultants who would do that for you. So this is a quick table on a list of material considerations and what's not material. So the examples on the left are things that are generally accepted as being relevant to planning and relevant for consideration by the officers. Obviously not everyone would apply in every case, but I think the list is a really good starter to help you focus your thoughts on what planning matters you might want to object on. The column on the right hand side is a non-material consideration. So they're things that people may very well be concerned about, and you have every right to be concerned about. They're obviously very important issues, but they just don't fall within the remit of planning. So the officer just isn't at liberty to kind of consider these things when they're making a decision or a recommendation about our planning application. So maybe just one example might be like concerns about structural damage to a property. We have a lot of people raising this when it comes to basements. They're concerned about the impact of a neighbour's basement excavation on their property, and it just isn't relevant to planning. It's more relevant to, for example, getting a party wall agreement or building control. So it's not something we could refuse an application on. So it's just important to understand, I think, the distinction between what is and isn't a planning issue. Having said all of that, I would always encourage people just to put it in your response if you're concerned about it, and not spend time kind of worrying about whether or not it's material or not. It's good to kind of be aware, but if you're concerned about it, put it in, and then the officer will be able to do the job of kind of sifting out what's relevant to them and what's not relevant, and will highlight that in their report when they come to write one. So this is just a quick example then of how you might consider kind of how you might go about approaching how to do a response. And I've just taken the example of building height, for example. So the first step would be to kind of sift out and consider what the most relevant policies say, both in the London plan and in the new local plan. So I haven't kind of repeated the whole policy because they're quite long, but London Plan 2021 has its own policy on tall buildings, as does the new Southwark Plan. And I've given just an example of one of the criteria there. I think there's quite a few, which I'm sure you all know. And you might want to try and go through each criteria and frame your points in terms of where you think the particular scheme does or doesn't comply with the policies. So, for example, this criteria is that it has to make a positive contribution to the London skyline and landscape. So if you kind of think, well, does it do that? And if it doesn't, it would be just useful to just repeat the policy and just say, well, I disagree. I don't think it does this because. So that can be really useful. Go through all the drawings and the supporting information. So obviously, with some of these major cases, there'd be a very large number of documents, but it's important to try and sift out which ones are relevant to the issue at hand. So in terms of height, you could look through the design and access statement. There might be some view studies showing like CGI images showing it in context with its kind of surroundings. Or townscape and visual impact assessment is another common document. And just have a look through those and just consider like whether or not you agree with the conclusions. Is there anything missing that you think it's important to make a full assessment? And if there is, just like flag that up to the case officer to say, oh, well, I actually think the view from this part of the park is really important and that hasn't been included and I think it needs to be. That was really useful to flag up in objection.